Sir Geoffrey Nice QC has been a barrister since 1971 and served as a judge in England since 1984. Between 1998 and 2006, he led the persecution of Slobodan Milosevic, former president of Serbia, at the UN's International Criminal Tribunal for the former Yugoslavia. In 2007, he has advised and represented states, applicants, and victims concerning international armed conflicts at the International Criminal Courts and elsewhere. He chaired the China Tribunal, a people's tribunal into forced organ harvesting. We give you the Honorable Sir Geoffrey.
Oh, thank you. Sorry, is Dr. Create to speak? No, just me. Okay. Well, thank you very much for inviting me to speak. Make sure you let me know if I'm not audible at any stage. There are a lot of people rather more interesting on this panel to hear from than me, and so given the time that's already passed, I'll keep my remarks as short as I can. As chairman of the China Tribunal into forced organ harvesting, and now chairman of the Uyghur Tribunal, it won't surprise you to know that I can actually say nothing personal, express no personal opinion really about anything to do with China and what China is doing at the moment or has done in the past, beyond what is contained in the China Tribunal judgment, which was published in full earlier last year. So I think that what I will do instead, and I hope this will help, is just say a few words about the process of the China Tribunal into forced organ harvesting. And for those of you not familiar with them, it is necessary to know just a little about people's tribunals in general. They have some use, but they're no panaceas. They are of some use when there is a gap, when governments or international organizations have failed to ask and answer a question that needs to be asked and answered. They've usually failed to do that for what are called geopolitical reasons. Often enough means they're frightened of the state concerned about which the question should be asked and answered. The history of these tribunals is, after the Second World War, fairly limited in numbers, at least in the European setting, many more perhaps in South America. But in Europe, the most famous one that started it was Lord Russell's People's Tribunal into the Vietnam War. It was a very flawed tribunal. It only tried one side of the conflict, and the panel members were all of a certain political persuasion, or nearly all of them, and hostile to the United States of America. So their judgment or decisions have perhaps little weight, and that may be the fate of the decisions of many of these tribunals. But Lord Russell, whatever the mistakes he made in the formulation of his tribunal, set a path along which others have trod. The most important other tribunal, before we come to the period of the tribunals with which we are immediately concerned, was probably the so-called Comfort Women Tribunal, which reported in 2000 on the sexual enslavement of women for the Japanese military in World War II. And for those of you not familiar with it, it's worth looking up. It's not always easy to find on the internet, but it's worth looking up. This was a major exercise of evidence gathering by non-governmental organizations from the very many countries in which women put into this terrible and sometimes deathly slavery were concerned. I first became involved in people's tribunals, knowing absolutely nothing about them, when I was asked to help out a little bit with the tribunal that dealt with the atrocities in Iran in the late 1980s when the opposition were slaughtered really, in various prisons. What was quite interesting from my point of view is I was asked to join, and I joined as a part of the advisory board. And there were a couple of other lawyers on the advisory board, and we gave the advice that lawyers tend to give. And by and large, our advice was rejected. And it was rejected by the organizers, and the organizers were pretty nearly always right. And we were wrong, which I suppose was an indicator to me that lawyers have always got to be a bit careful about venturing into activities outside those with which they are strictly familiar. But what I did notice about the Iran Tribunal was its immensely powerful effect for the people who had established it. The next tribunal I was concerned with was slightly less satisfactory, and I won't dwell on that, but I learned lessons from both of those tribunals. And then, I don't know, 5 years ago was it, I was asked by a man called Ben Rogers, of whom some of you will know, if I would write an opinion about the legality or the criminality of what may have been happening in the People's Republic of China by way of forced organ harvesting. And I told Ben Rogers that writing an opinion was probably a complete waste of time, because nobody would ever read my opinion, and they'd take no notice of it. I said, nevertheless, I'll do what I could, and had they thought of a People's Tribunal? And they hadn't. And I don't think they really wanted to, because they already had, from three of the people present at this conference, opinions in different forms, but following substantial research, leading in their judgment to complete certainty about what was happening. Why on earth would they want to have another body, a People's Tribunal, start all over again and possibly reach a different conclusion? But I dare say, and either Wendy Rogers or maybe David Metas or someone will be able to tell you, I guess the reason they eventually decided they'd like to have People's Tribunal was because the absolute certainty with which others had expressed views about what happened had nevertheless been turned down, rejected by country after country, always saying something like, well, we're not quite certain that the evidence is enough. And by government saying that, or something similar to that, they could justify doing nothing. And so a tribunal was set up. Susie Hughes of ETAC can tell you more about it. But the principles I applied, which I had drawn from observation of and experience in a couple of other tribunals, were the following. And they were built on this basic principle. If we, the people, are let down by governments and international organizations not doing what they should by asking and answering questions to which we need answers, then we shouldn't be too keen to imitate them. We shouldn't be like an ordinary court. We shouldn't be like a parliamentary committee. We should be the people. The people. So I wasn't interested particularly in forming a tribunal of lawyers or NGO specialists, and certainly not the people who were particularly knowledgeable about China. I was interested in forming a tribunal, to the extent possible, of people with a wide range of disciplines. And the Uyghur Tribunal, which has now been formed and built on the experience of the China Tribunal, is even more diverse and even less populated by people who might look like the usual people for such a job. A whole range of people in the Uyghur Tribunal and quite a wide range in the China Tribunal. And I wanted the tribunal to be pretty much like a jury. For those of you who know what juries are in either criminal or civil trials, they're a body of citizens who come to answer a question. And they are told right at the beginning of their job, make no assumptions, start with a blank sheet of paper. And that is what we did. Notwithstanding the very powerful conclusions that had already been reached by David Mattas, David Kilgour, and F. M. Gutman, he said, no, we're not interested in their opinions. We will, of course, look at the evidence upon which they've relied to form their opinion, and we'll look at all the other evidence. We'll try and find out what the position of the People's Republic of China was, and having started with a blank sheet of paper and putting on it nothing but evidence, and then saying, of what are we completely sure? What are we certain beyond reasonable doubt? And that led to the conclusions about forced organ harvesting, about crimes against humanity, but not genocide, that you will know of if you've read either the short or the long form of the judgment. And then what did we do? Well, largely, we just walked away. And that, I think, is very important. We were not activists. None of us knew of forced organ harvesting before we started work on this. We were not particularly sympathetic to the victims, if there are any, as we found there were, in China. We were just citizens answering a question. Now, you may think that that's denying ourselves the pleasure, maybe, of going further and banging the drum. But no. We judged, and I hope wisely, that having reached the factual and legal conclusions, because we had lawyers telling us what the law was, those of us who had a bit of law within the jury room didn't say what the law was. We waited to hear it from outside experts. Good. Having delivered our verdict like a jury, we said, it's not for us to make recommendations. It's not for us to tell everybody else what they should be doing. That would be overreaching to the greatest possible extent. We observe that educational establishments, businesses, travel companies, all sorts of other institutions that deal with China have to take account of this judgment of ours. But basically, all we did was to provide a judgment for others to use. Will this be as ineffective or apparently non-effective as many of the other people's tribunals has been? Maybe. But so far, one thing seems to be pretty clear. If a collection of citizens with no axes to grind, no background preconceptions, not activists, just deal with evidence that is presented to them. They have the right to call for some additional evidence and check things out, but basically just dealing with the evidence, just reading an answer to a single question, handing that answer over in the form of the judgment. Do you know what? It's very difficult for anyone to challenge that, especially if, as in the case of this judgment, all the reasoning of the ordinary citizen is on display. It's there to see. And in the year and a half, or 2 years, I suppose, since the judgment was first announced, it has not been deconstructed or challenged in detail by anyone. It is a judgment of a number of people working together, my colleagues and me, as equals. It is a judgment of the citizens, and it is there for all the other citizens to use. Because, and this is my last observation, when I say all the other citizens, which ones do I mean? I mean all the citizens of the world. Why do I say that? not particularly in relation to this, but in relation to any finding of gross criminality. After the Second World War, when there was some, at least temporary, maybe temporary, move away from the notion of the sovereign state to some forms of internationalism, globalization, which grew and may now be under threat again. When that started, with the 1948 Declaration of Human Rights, it was understood that rights were universal. And if rights are universal, duties are universal too. And they're not the duties of just governments. They're the duties of people. And therefore, if a finding is made that fundamentally breaches the rights of one group of people, the rest of us, whatever that breach may be, if it's grave enough, obvious enough, and made clear to us, that breach engages in us a duty to do something to put it right. Thank you.
Thank you, Sir Geoffrey. We look forward to your continued leadership and future work. Please note that there are 2 PDF files from the China Tribunal that's in the handouts. It's under the handouts tab on your control panel. Please feel free to open and download the PDF files.